You got your
no more angels.
It be the act of a party. Now you have recognized the majority as the party and writing a letter to the chief minister. This is unheard of.
So if a party
Obviously, it presupposes that he's giving some, imparting legitimacy, recognition, or some status. Well, how is that possible?
there's only one gray area.
In constitutional law, it's not possible.
Not so much from the facts of this case, but we're looking at now from the
Yes.
perspective. On the facts,
I'll tell Lordship,
when you read that letter of the 28th of June 2022, the governor, short while ago, you said that what the governor essentially did was to recognize a split by the letter. In fact, that letter does say that so many people have left you, and therefore, that
without using the word split, is a full recognition, my submission to Lordship.
de facto recognition of a split.
Yes.
Correct. Now, your answer to that is that the governor, so long as the disqualification petitions are pending, he cannot call for a trust vote for the simple reason that you are still a part then of the government which is supported when the House was formed.
Except in one case,
Right.
where, for some freak reason, which I cannot think of, it will never happen, that nobody decides to seek to disqualify the other. Now, suppose...
Often the speaker, what he may do is that, look,
No,
I don't disqualify you at all.
No, but that is not so simple.
They contribute to the majority of the
No, but I am doing a juristic answer to your Lordship's query. It can never arise in practice, but I am giving a juristic answer. That will have to be a situation where there is no cavil and dispute. I mean, it is virtually by consent of everybody. But with that answer comes a caveat. It goes back to the origin and the object of the 10th schedule. Why was it enacted? It was enacted not to encourage these trust vote situations by defections. Unless that is so, it will rise every week, every 2 weeks.
One of the last point, maybe you can take 2 minutes to put this to the other side also.
Yes.
So worry. There's no clear answer.
No, I'm very grateful because it helps us to clarify in our own minds also. Which is to clarify now.
There is, in assessing the strength of a ruling party in the House, whether it's the Legislative Assembly or the Parliament, you have a numerator and you have a denominator. The numerator represents the strength of the party when the House was formed. The denominator represents the total strength of the House. Now, by calling for a trust vote on 28th of June 2022, the governor, according to your argument, is that the governor therefore recognizes that a part of the numerator has evaporated or has been taken away.
It's rather nice for putting in numerator.
Yes, the numerator has been taken away. And therefore, now I feel you have lost the confidence in the House. According to you, that is not permissible because the disqualification petitions are still pending.
And he recognizes and gives legitimacy to the numerator. In your Lordship example, he is recognizing and giving legitimacy to the numerator.
The only problem which I think, which is kind of not, which is worrying is, does the governor not also recognize that the very act by which the numerator may or may not be affected? All right. For instance, the numerator would be affected even if you don't treat it as a split, and there's a clear disqualification. Then the numerator is reduced by X, the strength of the ruling party in the House, minus Y, the people who have defected from, who have therefore attained disqualification. But equally, that same act affects the denominator also.
Because it reduces the total strength.
The total strength of the House.
Correct.
So, though the governor cannot therefore say, the governor cannot legitimately say that, look, these people have left you, therefore I want to trust.
Correct.
But can the governor not then say that, look, assuming that there is no recognizable concept of a split now under the 10th schedule, the effect of all this is that these people have to be reduced both from the numerator and the denominator.
Straight away. There are many answers. First, this exercise cannot be done by the governor because there is no mechanism for it generally.
You have been arguing that he can't assume to himself to take a decision.
First, I give Lordship 3 or 4 answers. Lordship will note down my very specific answer. This is an exercise itself which he cannot embark upon. The governor has no such jurisdiction to embark upon when there is a running house. Now, second
That's
answer.
right. He can't embark. But can you not, therefore, they then say, I want this exercise to be demonstrated on the floor of
No,
the
therefore, no, I'm saying that exercise you can't embark. Let me answer.
Can you not?
Yeah,
That's
answer.
He has
Yes.
argued that. He
Second
has
answer.
argued that he won't have the. It has to be.
Whereas numerator, denominator, you can't start because your lordship has to premise a direction by me to him. I'm the governor, I'm giving him a direction.
So in other words,
Please have
your
the,
argument.
you can't give a direction.
Got your point. Therefore, to
The legislature, the speaker or the chief minister can say, sorry, I don't obey this direction. I don't.
finish your argument, therefore, until the outcome of the disqualification petitions is known to the governor,
Exactly.
he cannot then pause for a
Plus two or three. Your lordship will take.
possibly, using your line of argument, we're just trying to understand the
Yes.
argument and stretch it to its conclusion. After the disqualification petitions are decided by the speaker, then there is clarity in the mind of the governor on what is the extent of the numerator which has been affected.
I'm very grateful. I was going to answer, I'm not conceding, but I was going to answer because that question doesn't arise. Your lordship will be very careful about a hypothetical situation, but possibly were. But why is that? Because a constitutional designated judicial or quasi-judicial tribunal has given a verdict. After that, there is something, as the lordship puts it, that verdict, unless disturbed by the High Court or the Supreme Court, is binding or operating. But here, your lordship's query answers the first part.
There is also
You are doing it well before.
There is another point in your favor, actually, which is that the very same unit which affects the numerator affects the denominator also.
Yes, yes.
Right? So if the governor cannot postulate until the disqualification petitions have ended that the numerator has been affected, then he cannot say that the denominator is affected.
No, he cannot. By the very arithmetic, it has to be both. It is very selective otherwise.
Right. Because the same act of defection which reduces the strength of the ruling party, which also then affects the strength of the house.
And Manas, can you start doing this? This is the word premature stares your lordship in the face. Constitution says this body will decide. This body is ready to decide. You are going to give a decision virtually. I will reduce the denominator, I will reduce the numerator. That will create chaos. And Malas, your lordship has to see Malas
You are saying
also
he can't take cognizance of the existence of the 10th schedule proceedings. He can take only upon an order passed by.
consequence of the 10th schedule proceeding.
After a determination by the 10th.
That's a very pithy summary. The consequence of the 10th schedule can be some basis, unless disturbed by the High Court or Supreme Court, to act.
Until then, they continue to be members of the.
And it would be in rem. Once that,
Otherwise, this would be really a method.
there'll be chaos. There'll be chaos. And Manas, not that it should come into your lordship cannot Manas, ignore the reality Manas, of around the country. Governors also.
We got your
Governors are no more angels.
Just 2 sentences. Number one, Malaj. 10th schedule doesn't recognize majority minority.
Absolutely.
Correct? 10th schedule postulates, Malaj, that even if there is a split of a majority, it can't be recognized. The governor knows that. The governor knows that, Malaj. And Malaj, 10th schedule, also, para 3 also said there must be a split in the original political party. 10th schedule, Malaj, para 3 said original political. Right. We know that there was no split. Governor knows there was no split in the original political party. So on what basis will he ever recognize? And your answer to your lordship's question, how will the governor call Malaj? Supposing one of the parties moves away from the coalition and goes to the governor, along with the BJP, and said, now we are.
That's not an individual act of defection.
Yes, that's right. So this is an individual act. It has to be the act of a party. Now you have recognized the majority as the party and writing a letter to the chief minister. This is unheard of.
So if a party says we don't support the government anymore, that's not a disqualification.
That's
We don't support. The governor says you lost one of your constituents.
Government falls.
That's fine. That's all right. So that I'm sorry for that. I didn't want to.
Very deeply obliged.
Thank you, Dr.
Thank you, Doctor.
Yes.
Wait, please, for some Lords, I'll be very brief, Lords, for 15-20 minutes. Lords, some issues have not been covered.
What are the points that you want?
Yes, straight away. Lords, I have made a brief written note, but before it's a quasi-judicial, Lords, adjudication under the symbols order. That, Lord, adjudication of the dispute results in an order declaring, my lord, XYZ as representing the political party. And this submission is, my lord, that can only have a prospective effect. Now, my lords, kindly see the consequence. If it is held otherwise, that it relates back, it would have, my lord, in our respectful submission, complete, my lord, disastrous consequences as far as the 10th schedule is concerned. Because when the decision comes, for instance, in this case, it has come in February, my lord. Petition moved in on 19th of July. And today to say that in view of this decision now, in February 2023, all the actions of prohibited conduct get effaced, my lord, would be to destroy the complete intent, letter and spirit, my lord, of the 10th schedule.